Yes, Mr. Chairman, distinguished honorable members of this ad hoc committee. In the course of the proceedings of 24th day of November 2017, a question was raised relating to a letter dated 21st day of February 2017, purported to have emanated from my office. And my reaction to it, even though I had made my position known to our brothers at the Senate, I felt I should equally make an addendum that is intended primarily to shed light arising from the letter dated 21st February, which addendum has been submitted to this committee. I am happy now to report that I have carried out necessary inquiries, and my conclusion relating to the letter dated 21st February 2017 is that as at 15th October 2017, Maina's issue relating to a request for reinstatement pursuant to a letter made available and submitted to the Office of the Attorney General for consideration was indeed a work in progress and was not consummated to the point of issuance of a final letter conveying directives of reinstatement of Maina because of the following reasons. One, the Honorable Attorney General of the Federation received a letter from Restoration Chambers dated 9th day of February 2017 on behalf of Maina, which letter was received in my office on 13th February 2017. Two, the Attorney General instructed a legal advisor in his office to treat the letter on the complaint of illegal dismissal submitted to the Office of the Attorney General by Restoration Chambers on behalf of Maina. Three, in a subsequent communication dated 23rd day of April 2017, which was in response to a memo developed by Special Advisor Kehinde Ogini of 11th April 2017, the Attorney General requested the Special Advisor who suggested the reinstatement of Maina arising from the conclusions in the memo to advise on how consequential effect of the judgment in support of his solicitor's letter could translate into the reinstatement of Maina. The minutes on the process read as follows. S.A. Kehinde, please advise further on the ways in which consequential effect to the judgment in paragraph 4 could translate into reinstatement of Maina and revert. That minute was dated 23rd April 2017, and a copy of the memo and minute is attached as Annexure 2. Without addressing the inquiry in paragraph 3, the Special Advisor reverted again with another memo on 27th April 2017, in which he provided additional information on Maina's issue and alluded to the court processes without attaching the said court documents on the basis of which second memo was based, and the Attorney General requested that he should provide copies of the National Industrial Court process, which was referred to, and a report on all the associated pending cases referred to in the memo. The minutes of the Attorney General on the memo reads as follows. Please get copies of the processes filed at National Industrial Court by Maina and report also on the developments relating to the case and revert. That minute is dated 19th May 2017, and a copy is attached as Annexure 3. So there was no further correspondence from the Special Advisor up to around October 5th, 2017, when the line officer came off with a clean copy of a letter addressed to the Chairman, Federal Civil Service Commission for my signature. The letter expressly contained a conclusion that Abdurrashid Maina be reinstated back to public service and promoted. the Attorney General directed the line officer to keep the letter for further review and never sign off on it. It is minuted thus, SAKND KIV, and that was 19th. The minute was on the 19th May 2017. A copy is equally attached. So it is against the background of this unfinished process relating to demand or request for the SA to convince the Attorney General as to how the effect of judgment provided by Maina could have consequential effect of reinstatement, which was not developed and presented. The request by the Attorney General that he should provide copies of the National Industrial Court of Nigeria process and a report on all the associated pending cases referred to in the memo, which were not made available and presented, and the fact that the letter dated 5th day of October 2017, which was never signed off on that, I arrive at irresistible conclusion that Maina's request for reinstatement was an ongoing process in the office of the Attorney General as at 5th day of October 2017, and the purported letter dated 21st February 2017 made available by the committee couldn't have genuinely emanated from the Attorney General. Again, I think it is material to state also that the letter dated 21st February 2017 couldn't have genuinely emanated from the office of the Attorney General, having been lacking in procedural compliance as it obtains in the office of the Attorney General relating to processing of documents. In relation to requests for legal opinion or interventions made by ministries, departments, and agencies or individuals, the procedure in the office of the Attorney General is as follows. 1. The document requesting for legal opinion intervention is minuted by the Attorney General to a line officer to review, advise, and revert. 2. On receipt of the minutes by the line officer, he develops a memo making observations and recommendations. 3. Arising from recommendations, the Attorney General now gives further directives to the line officer approving appropriate recommendations and, in most cases, directing the line officer to act further. 4. Where the need for correspondence with a third or interested party arises, the Attorney General directs the drafting officer to draft necessary correspondence, which is further vetted by the Attorney General upon presentation by the line officer. So in essence, a communication from this process is a product of a request for opinion or intervention, minuting by the Attorney General to a line officer developing a memo, minutes of the Attorney General approving the recommendations or otherwise in the memo, and further directives in case of correspondence with a third party, directing the draft of a letter for such communication, and minutes from Attorney General approving the draft for communication, and then final clean copy of the letter to be signed by the Attorney General. I have gone through the associated files and records in the office and wish to confirm to the committee that no such antecedents exist in relation to the purported letter dated 21st February 2017. In fact, the incidences associated with the subject matter in proof of the fact that it was a work in progress as at 5th October 2017 belies the possibility of responsibility of the Office of the Attorney General relating to the letter dated 21st February 2017. Going forward, arising from that disclosure, I have directed the Solicitor General of the Federation and Permanent Secretary to constitute a committee to investigate the case and revert with a report. In furtherance to paragraph 29 of principal presentation, it is equally important to make a copy of the petition. And Mr. Chairman, in the principal presentation I made reference to a petition which was not made available, and I think it is equally important to make a copy of the petition available. It is a copy of the said petition which is annexed as Annex 5 in proof of the allegation that issues relating to pension scheme are substantially been compromised over time, Annex 5 is a petition against a senator of the Federal Republic of Nigeria, as he then was, that was made available to the security agencies for investigation, which was never investigated. I thank you, Mr. Chairman.